Ladies and gentlemen, Assalamu alaikum. I was asked by Justice Jawad Hassan just to give some closing remarks, but here goes. The facts and figures that were given by Mr. Umar Gilani were noted with great interest and keenness by me, but also with a little bit of amusement, which is a little more than keenness. The company cases that are pending before the Islamabad High Court are in two categories. Some of them are highly complex, whereas as far as liquidation is concerned, there is a very large propensity by litigants to file liquidation petitions by treating them as a more effective alternative to suits for recoveries. There may be a default by a company in paying its liabilities, but the refusal to pay must not be equated with inability to pay. So the company judge ought to be aware that the company law ought not to be misused, and where there is an alternative to institute a suit for recovery before the court of competent jurisdiction, it is that avenue that must be availed and not a petition for liquidation. What the ingredients are for a company to be liquidated now is very well settled by a catenary of case law. But the most essential factor is that the substratum of the company should have gone. It should not be in a position to pay its liabilities. Its assets should be lesser than its liabilities. It cannot be a going concern. There is no chance of capital injection in that company. The time limit that is prescribed for deciding such petitions, in my view, is unreasonable, because a company judge's endeavor must be to save the company. All efforts should be made to save the company, because an order for liquidation, you must realize, amounts to a coup de grace. You kill the company, you hand it over to the liquidator, and the liquidator's responsibility starts. First of all, he has to pay himself, and then the preferential creditors, and so on and so forth. So a judge's responsibility must be to explore every avenue to save the company. As regards the liquidators, I have found that in the Islamabad bar, we have some extremely proficient lawyers whose expertise in the field of company law are very wide and have done very well as liquidators. But it would be a welcome development if the SECP would provide us with a panel of liquidators whose credentials are scrutinized, and they have been through some sort of a training process before they are placed on the panel, and the same is provided to us. At times we do have a difficulty in choosing one or the other. As far as the cases that come before us in liquidation, they do not come to an end when a liquidation order is passed. The reason why they take a very long time is because the court, although correctly said, is there to supervise the liquidation, but you must realize that all the litigation that is filed against the company for which a liquidation order is to be made, before that order is made or after that order is made, has to come before the company judge who is adjudicating upon the liquidation. There may be several cases pending before the civil courts, pending before different other forums. They will all have to be brought and adjudicated upon by the judge who is before whom the liquidation petition is pending. And it is the adjudication of those cases along with the liquidation that is going on after the liquidation order is passed that contributes to, in a substantial manner, the delay that takes place in their adjudication. The SECP ought to play a more proactive role in having a larger team of legal advisors than they have now. I'm not casting aspersions on any of the panel of the legal advisors that are there now. They come and they render very good assistance, but we would appreciate if that panel is enhanced. And there are larger number of lawyers who can come to the Islamabad High Court at least and give us assistance as far as not just liquidation cases are concerned, but the cases which in my view would be more complex than liquidation are those of the rectification of share registers. The litigation pertaining to the rectification of share register is as much as the winding up petitions. And we have seen that there is a greater propensity in the SECP to wash their hands of deciding those rectificatory matters by saying that these are disputed questions of fact and ought to be adjudicated by a court of law. I would urge the SECP to leave that as a last resort, and only in cases which just cannot be decided without the recording of evidence should such an order be made. As far as rectification of share register disputes are concerned, they are of a multifarious nature. Normally, it's between the directors, and the SECP's supervisory role in such matters is most essential because, say for instance, where there is a case of an enhancement of the share capital, the SECP has to come up with the requisite documentation that the appropriate notice was issued, that the circular was filed in time, and if it is not done, what are the consequences? Do you pass an order doing away with all that process, or where a substantial period of time has passed and the directors who do come and file a petition for the rectification of share register so that they could be included as shareholders with the option to have right shares, do they have a case or do they have a firm legal foundation to stand on? I was supposed to just close this symposium, but one could go on and on. But this is a very welcome development, and the SECP and the Islamabad High Court ought to sit together. We can make that convenient. At least the company judges that we have in the Islamabad High Court, for these matters to be adjudicated upon swiftly. I absolutely agree with the Honorable former Chief Justice that there should be dedicated judges to take care of these company matters. If that is not possible, we should at least have a dedicated period within which these company matters can be settled. It is quite awkward for us to come out of the writ jurisdiction mode and then go into a criminal mode, then go into a family mode, and then into the company mode, all in the same day. So it would be a welcome development if there is a dedicated day for deciding these company matters. I won't bore you anymore. Thank you so much.